morning, everyone. So I'm Deb Finch. I am the regional coordinator for Libro Credit Union in Huron and Perth counties. Libro has been a supporter of seminars like this one for many, many years. A little bit about Libro. We're a financial cooperative focused solely in Southwestern Ontario. Our purpose is to grow prosperity in Southwestern Ontario and in our communities by transforming banking. Community is important to Libro. The regional economy matters, and our individual and collective successes support each other. That's the cooperative approach and social purpose. Speaking of social purpose, Libro is also a B Corp. B Corps are businesses that balance profit and purpose. B Corp is a global community of leaders driving a global movement of people using business as a force for good. At Libro, we use our business as a force for good. We understand that through our products and services, operations, business practices, partnerships, and collaborations, that we can impact our communities in a positive way and help address some of the most challenging issues in Southwestern Ontario these days. We've identified 4 Libro pillars as the key areas that we focus on to deliver our promise to grow prosperity in Southwestern Ontario. These are, just gotta bring up my sticker here, I lost it. There, so these are employment, increasing productive employment and decent work for all, reducing talent shortages, and supporting key business segments such as agriculture and small business, including social enterprises and cooperatives. The next pillar is financial resilience, improving financial capacity and resilience of people, businesses, and organizations like all of you. Local food accessibility is a pillar where we strive to improve food systems to increase access to local food for everyone. And the 4th pillar is housing, enhancing access to adequate, safe, and affordable housing for all. So all of these pillars are very much aligned to the values of United Way. One way we can support like-minded organizations is through our grants, sponsorships, and partnerships program. Some recent examples of organizations that we've supported include the Gateway Center of Excellence for Rural Health, the Goderich Community Gardens, the local community food center in Stratford, ShelterLink, the Technical Training Group, as well as both Optimism Place and the Huron Women's Shelter. So there's a number of different sponsorship levels, and I encourage all of you to find out more on our website on libro.ca.
Great, thank you so much, Deb, and to Libro for all your support of United Way, as well as all of the other organizations listed. Today, we are going to be discussing the Ontario Business Registry and the Ontario Not-for-Profit Corporations Act. This meeting will be recorded and available for reference later and or to pass on to colleagues within the not-for-profit and charitable sector. I'm going to introduce Keith Masterman today as our speaker. Keith is a lawyer with over 30 years experience. He has experience in legal risk management and in estate and trust. He holds a trust and estate practitioner designation. He joined CI Global Asset Management in 2015 after being an executive with one of Canada's major banks, where he worked in the estate and legal risk fields. Prior to joining the bank, Keith was in the private practice of law, working in litigation and estate planning areas of the firm. In addition, Keith has been an instructor in legal risk management at both university undergraduate and graduate programs for over 30 years. Keith is a frequent speaker at industry events and has spoken to Canadian Gift Planners Association, Abacus, and STEP Canada. And most importantly, Keith is also a board member of United Way. Welcome, Keith, and thank you so much.
Well, thanks very much. Here, I'll share my screen because I did do a little deck. So I'll just get that in front of me. Hopefully you guys will be able to see it in a minute. Is it there? Yay. I'm going to assume silence is yes, and Joelle's nodding away. So thanks very much for inviting me here today. I really think this is really special because I'm sure this is the one and the only time I'm going to be invited to this group, because nothing bores people more than about an hour on a regulatory and statutory change. So I suspect you're going to leave thinking, wow, that was kind of dull, but it is very important. So over the next hour or so, I'm going to review with you the new Ontario Not-for-Profit Corporations Act, which comes into effect, as you all know, I'm sure, on October 19th. It's been a long time coming. The Act originally received royal assent back in October 25th, 2010, so over 11 years ago. It's almost 11 years to the day from when it will actually go into effect. I'm hoping today is not just me talking. I'm hoping that some of you who have already delved into this Act in detail and are already building your plans for what to do in the future, I hope you guys are sharing with us all best practices and what you're finding as you go through it. So I'm hoping to have some conversation going as well. Since the time of its proclamation, it has been delayed at least 3 different times, and it's been amended by statute at least twice. Along that way, a series of regulations has also been drafted, but the government has already told us that there's going to be more regulations coming, and they've already told us that some of the current regulations they've looked at again, and they're going to want to amend them. So it's a bit of a flux right now. In part, the delay has been caused because the ministry has been upgrading its technology required to implement the Ontario Business Registry, which comes into effect on the exact same day, October 19th, and is really a huge part of the new changes. And with that, I'm going to say a few words about the Ontario Business Registry. The new registry allows all Ontario corporations, not-for-profit corporations included, so all corporations, to access government services online 24 hours a day, 365 days a year, with instant fulfillment and automation notices. So it's supposed to really speed up the process and make it easier to file material with the Ontario government, and it's also supposed to speed up tremendously the incorporation process. It'll allow the corporations to complete more than 90 different transactions, which used to have to be done through paper, including registering a new business and dissolving an existing business online. I'm not going to delve in too deeply into the new registry, but a few things I do think are important to remember as the new registry comes into effect. First, on October 18th, so 1 day before the registry comes into effect, current registry business will be halted. The regional offices will all be closed, and this is because the minister is starting to migrate from the old paper-based system to the new electronic system. The work halted, so all the things that are in the queue to be actioned by the Ontario government right now will not be picked up and started again. Once it's halted, it is halted. The business is over. This will mean that any documents submitted after September 17th may never be actioned. Any documents not actioned prior to October 18th will be returned to the corporation that filed them, and the corporation will be instructed to resubmit them using the new electronic system. So if you're about to file stuff, you might want to hold off because we're in that difficult stage right now. The ministry has a sign-up page, and I've put the address of the sign-up page online, where you will automatically receive information on how to access the site, the services that will now be automated, and how to complete registrations under the site. So that's just a little bit about the Ontario Business Registry and a few things to watch over the next few weeks about when you're filing stuff. So with that brief introduction, what am I going to talk about today, and what am I hopefully going to get a conversation with you guys going about today? Well, first, I want to do a brief overview of the new Act and summarize its most significant changes. I then want to look into what's the homework. So what are the steps required in order to ensure you are fully prepared for the new world? What are the things that have to be put into place? And then I'm going to talk a little bit about the role of the directors and some of the changes to the directors' roles. And then I want to look a little bit at members and some of the changes associated with members. And the reason I've decided to do those two lumps is because when I was looking at the Act as a whole, and as you guys know, the Act is saying that there are things in your bylaw you might want to change, there are things in your bylaws you have to change, things in your articles you have to change to comply with the new Act. When I looked at the role of the directors and members, an awful lot of the things that we're going to have to review sort of jumped out at me. So I was going to use those two roles to talk about some of the things that we're going to have to look at. So by way of overview of the new Act, might sound very, very basic, but I think the place to start is by asking, does this act apply to your organization? ONCA, the Ontario Not-for-Profits Corporations Act, applies to corporations that do not have share capital and which are incorporated provincially in Ontario. It doesn't apply to co-ops or organizations governed by the Cooperative Corporations Act. And also, if your corporation was incorporated federally, your organization was incorporated federally, or in another province, or it's a co-op, that act doesn't apply to you. It applies to everyone else, all corporations incorporated in Ontario. Now, there has been an article that I just thought I'd raise with you guys in one of the legal journals I get that suggested that some organizations might want to start at ground zero and say to themselves, does it make sense to still be a provincially regulated business, or should we change to being a federally regulated business just to avoid all the changes and all the disruption that ONCA is going to create? Personally, I think that's a bit of overkill because I think the whole goal of ONCA is to increase transparency and to make things easier. But I also understand the viewpoint of some lawyers saying, you know, it might be a good place just to sit back and say, given all the changes and everything that's going to happen and some of the confusion that might come out of ONCA, it might be best to consider redoing our corporation into a federal corporation instead of a provincial corporation. The Act sets out a series of goals, which I've set out in this slide. You'll notice when you look at the goals, this slide and the next slide, you'll notice that some words I put in black, sort of a bold font. That's because I'm trying to get through the idea that some of the changes that are coming are mandatory and some are optional. So there are some things that are going to happen to your corporation or to your organization, and some things that you can choose to happen to your organization when you look at your bylaws and articles. So when I looked at the stated purposes of the Act, I tried to sort of highlight where I saw mandatory or optional wording. I also have broken down the stated purposes of the Act into these four categories, those being incorporation, first of all, financial oversight, and then we'll get into the other two when we switch sides, which are articles of incorporation and governance. So from the incorporation process, they're trying to improve the efficiency of the incorporation process. I'm not going to go into detail about that because that really is looking at the business registry, and the system is all set out there about how that's going to be done electronically. But one of the stated purposes, and one of the things in incorporation that's going to make incorporation a little bit easier, is they're removing the public guardian trustee from the approval process for incorporation of charitable corporations. So that's a few things from the incorporation front. From the financial oversight, and I think these are some of the most important changes in ONCA, if you ask me, they're trying to simplify the financial records review process through the introduction of a new audit process. So what they're going to do is they're going to say, and we'll go into more detail about this, I have a whole slide on this, but what they're basically saying is whether your organization requires an audit or not is going to depend on a few drivers, one of which is the gross revenue of your corporation or your organization, one of which is whether your organization falls into this new category they're creating of public benefit corporations, which we'll talk about as well, so they're going to distinguish between those. And one of them, I guess those are the main two. So they're setting up this new system where you might not have to get an audit. You might be able to get away with a slightly different system. From the Articles of Incorporation, the stated purposes include some changes to the Articles of Incorporation. And that's, first of all, that they mandate that the Articles of Incorporation must set out the classes of members of your organization where there are more than one class. So if your organization has two different classes of members, your articles must specify the two different groups of members. If they don't, they're going to have to be amended. If they're not amended, then the ONCA default rules will eventually apply to your organization, and we'll go through when, and you'll suddenly find yourself with only one group of members. And finally, the governing and corporate oversight aspects. So these are just sort of a whole bunch of their purposes that I sort of set out into this category. First, they're trying to clarify the rules for governing the corporation and increasing accountability. Secondly, they're allowing corporations to pass bylaws to provide alternate voting methods. So basically now you can organize bylaws that say you can vote by mail, by telephone, or electronically. Thirdly, they're going to permit the appointment of a proxy holder. if it's allowed in your articles or in your bylaws. So again, you're going to have to look at your bylaws and articles if you want a proxy holder and say, are we already allowed to do that? They're going to clarify when a corporation may engage in commercial activity. Basically, the new rule is if a corporation undertakes a commercial activity, as long as it supports the not-for-profit purpose, it's permissible. For example, a corporation may want to sell t-shirts or socks with hearts on them, etc. And as long as the profit from the sale is used to support the business's not-for-profit purpose, it's permitted. So they're trying to clarify that. They're going to provide directors with a new due diligence and good faith defense, and we'll talk about that when we get into the directors. They're going to specify the requirements for directors and officers to report conflicts of interest. So there's a whole section of the Act that talks about what is a conflict of interest. It develops this whole process that a conflict is not just simply a stagnant point in time. So simply because I go to a board meeting and I put up my hand and say, I have a conflict of interest in that particular contract, doesn't end the discussion, because they're saying a conflict might come up after the fact as I change employers or whatever happens to me. So they're developing a new conflict of interest process. And they're allowing members increased mechanisms to advance claims if they think directors or officers are not acting in the corporation's best interest. And basically what they're doing there is they're trying to create two remedies. One of them is a derivative action. And I don't know if many of you know what a derivative action is, but suffice it to say, it is when a member brings an action on behalf of the organization, in the name of the organization. So they're allowing members, if they think there's been abuse by the board of directors or the officers, to bring this derivative action in the name of the organization to seek a remedy on behalf of the organization. I don't think that's going to be very popular. It's not very popular with a profit corporation, so I don't think it's going to be very popular in the not-for-profit sector. But the other remedy might be, they're creating an oppression remedy. And I don't know if many of you know what happens in the federal Not-for-Profit Corporations Act, but they already have an oppression remedy. And what an oppression remedy basically says is that the court may make an order if they feel that there's been an act or an omission or conduct or activities by directors or officers that are oppressive to the members or a member or a class of members. So in the new world, a member will be able to look at everything that the organization does and say, that's oppressive. That's oppressive to my membership or to members in general. And they can bring a court application seeking a remedy of the court to end the oppression. Now, the court doesn't have wide jurisdiction, but they do have jurisdiction to order an inspector, order documents to be disclosed, order someone to come to court and testify on behalf of their actions to give the member further understanding of what's happened. So those are sort of the stated purposes and some of the really high level changes that are happening. So how are they going to implement all these changes? How are they going to have more transparency in the oppression remedy and all those things we just talked about? Well, ONCA develops 3 different types of rules. The first rules are mandatory rules. And these are rules that can't be overridden by your articles or bylaws. You're stuck with them. For instance, you must have at least one class of members. The bylaw must set out the conditions for memberships of each class. If there are 2 or more members, your articles of incorporation must set out the 2 different categories and the rules associated with those. So those are mandatory rules. And part of the trick over the next little while is to look at all your articles and all your bylaws and say, is this a mandatory rule? Do my articles and bylaws reflect it? Then there's a series of default rules. And these are rules that will apply to your organization unless your bylaw provides a different structure. So these are things like terminating members and membership right. There's a whole section of ONCA that says, how do we terminate a member? Those things will be deemed to apply to your organization unless you've got a default bylaw that says, this is how we're going to do this. They're allowing you to develop your own structure, in other words. But if you don't develop your own structure, you're going to be stuck with the default rules. And then alternative rules, which are a little rarer, but alternative rules are rules that they're giving suggested language. So in the one of the tools that they've developed, and you'll see it there under alternative rules, is they've developed draft bylaws that they're suggesting organizations might want to consider. And within those, there's sort of alternative rules that say, you don't have to do this, and it's not going to be forced on your organization, but we think it's kind of a neat bylaw and you might want to consider it. It's sort of a help bylaw, if you will. So the other concept that I mentioned earlier, I think I've mentioned it a couple times, is the public benefit corporation. I would be very surprised if about 95% of the people on the phone do not work for a public benefit corporation right now. But a public benefit corporation is defined as including charitable corporations, and that's why I suspect about 95% of us are involved with a public benefit corporation already, or a non-charitable corporation that receives at least $10,000 in a financial year in either donations or gifts from persons who are not members, not directors, not officers, and not employees of the corporation, so the general public. So if you get more than $10,000 and you're not a charitable corporation, you're still going to be a public benefit corporation. There's also one other way of becoming a public benefit corporation, and that is if you get $10,000 a year from financial assistance from a government or a government agency. So if you get more than $10,000 a year, you are not a charitable corporation. You're still going to be a public benefit corporation. So I suspect 95% of us are public benefit corporations. What happens if you fall into the category of public benefit corporation and you're not a charitable corporation? In other words, you fall into it because you got more than $10,000 from the general public or from a government agency. Well, if you fall into that category, you will be deemed to be a public benefit corporation, and the rules associated with public benefit corporations will apply to you for the next fiscal year. And then there's going to have to be a review again. So your status might change. One year you might have more than the $10,000 that makes you a public benefit corporation. One year you might not, which makes it a little awkward to know how exactly to set up your bylaws and your articles. Because there are certain consequences to being a public benefit corporation. The third and fourth dots don't really matter much, but the first two do. If you are a public benefit corporation, no more than 1/3 of your directors may be employees of the corporation. And that's the tough part. If you fall into that category, not because you're a charitable corporation, because of the funding, your status might change. And you might now provide that all my directors can be employees, or 5 of my directors can be employees, but you can't do that anymore if you're a public benefit corporation. So you might be left with the terrible governance moment when you're saying, wow, we just fell into this category. Here's the new rules. Some of my directors can no longer be directors. We'll also discuss the thresholds provided in the Act for dispensing with an audit. I mentioned that one of the main features of this whole thing is that they've changed the audit function, or the necessity for an audit. So we'll talk about those in a minute, but suffice it to say right now, if you are a PCB, public benefit corporation, your ability to waive an audit is different than if you are not. It's a slightly higher requirement. And the tabs 3 or 4, or dots 3 or 4, whatever you want to call them, really have to do with the steps required when you dissolve the corporation and where the funds may go in the corporation. So I've talked to you a little bit about the new audit requirements. So let's look at what they are. Arguably, the most important aspect of the new being a PBC, and one of the most significant changes in the Act overall, is the establishment of the new audit requirements. And I think these new audit requirements, quite frankly, are really welcome. I talked to one of the accountants who sits on our board yesterday, and I said, what do you think of the new audit requirements? And they said, these are fantastic, because what they're really saying to small organizations is, we realize it's expensive to do an audit, it's time consuming, and also we understand it's very difficult to find someone to do an audit for some organizations. So the government seems to have realized that, and they've set up these new audit requirements. So the Act provides that under certain conditions, the requirement for an audit can be waived by the corporation. In most cases, the audit requirement is replaced by a review engagement, which is a much lower threshold. It doesn't include testing, and it's a lot cheaper and easier for an accountant to complete. However, in one circumstance, both the requirement of an audit and a review engagement may be waived. So if you look at my handy dandy little chart I put together, You will notice that if you are a non-PCB, I think it is, oh no, if you are, yeah, if you're a non-PCB earning $500,000 or less in revenue, so you don't fall into those categories, you may dispense with both an audit and a review engagement by an extraordinary resolution of your board, that's 80, of your members, that's 80%. Everyone else is going to have an audit or a review engagement, and it depends on your gross revenue. So again, if you have gross revenue of $100,000 or less and you're a PCB, you can dispense with an audit and or a review engagement by extraordinary resolution. So I guess I misstepped that. That's also one that can waive. 100 to 500,000, you can elect to have a review engagement instead of an audit. And if it's $500,000 or more in gross revenue, if you're a PBC, you have to have an audit. You have to have a full audit appointed. So those are some of the changes associated with that. I will keep going unless I hear people who say, no, I want to talk about something. No. So what's the homework? So I briefly laid out some of the changes in ONCA and some of the major changes included in it, setting out some of the mandatory rules and optional rules, and we'll go into a little more detail. But what does that mean is the homework for not-for-profit organizations today? Well, basically, effectively, not-for-profit organizations have two options. One, you can do absolutely nothing. That was sort of my son's view on homework when he was back in high school, so I know a fair amount about that option. Or you can start doing a review of your bylaws and articles to ensure they comply with ONCA. Both options are allowed under the legislation. What the legislation does say is you have a 3-year window after October 17th. So the clock starts ticking October 17th. And during that 3-year window, the organizations will be continued to be engaged by your current bylaws and articles. So nothing changes whatsoever. You wake up on October 18th, 19th, 20th, your bylaws, your articles are fine. That's going to govern your organization. However, after that 3-year window, your articles and bylaws must align with the requirements of ONCA. Any provision that is inconsistent with ONCA is deemed to be amended to comply, or if it can't be amended to comply, it is deemed to be void. So therefore, if you just take option number 1 and do absolutely nothing and wait out the 3-year period, you're going to have a very uncertain and messy set of books after the 3-year period. Because what you're going to find is suddenly you have articles that say one thing, bylaws, and on the other hand, you have, but on the other hand, some of those are deemed void, and some of them are deemed amended, and you really have no idea which ones will say what. So really, the best action to take is over the next 3 years to do sort of a forensic review of your bylaws and your articles, and make sure that they comply, and make sure where you can set out alternative provisions, you've got those alternate provisions in place. Now, I heard some noise. I don't know if someone was trying to ask a question or make a comment, but I will briefly pause and see if anything comes up.
I think it was just someone that was unmuted, Keith, but thank you.
Okay.
Doing great, by the way.
You're very kind. So anyway, so what I did was I put this process map in place for what you might want to do if you decide that over the next 3 years you do want to review the bylaws and articles. And I'll remind you that 3 years sounds like a long time, but it's not. It's a very short time when you think of amending your bylaws, filing the amendments, dealing with CRA, all those things you have to do when you make changes. And so I would suggest that if you are going to be one of those corporations, and I know United Way is going to be one of those corporations, you start looking at it sooner rather than later. But from a process maps perspective, there are 5 steps to take over the next 3 years. First of all, determine if ONCA applies to your organization. We talked about that at the very start. I think it's important to sort of look at your organization and say, is this a co-op? Is it incorporated provincially? And if it is, it's not the end of the story, because I do think that you know, the person who did the legal argument that talked about, or the legal article that talked about, you might want to actually move to the federal jurisdiction, it might be an opportunity for you at least to talk about that with your organization. Second is collect and review the governing documents that may be affected by ONCA, which is basically everything. It's in particular your bylaws that deal with members, your bylaws that deal with directors, and your articles of incorporation are going to be the three things that really are hit the hardest. Then it's to review the ONCA requirements and your articles to determine what changes must and may be made. So must is one category, may is a second one. I think a best practice for how to sort of deal with this is a good place to start is looking at the draft articles provided under ONCA. So the government has issued draft articles. I know Megan and I have looked at them a couple of times over the last couple of years, that they're saying, these are perfect. This sets out the ONCA requirements, and sort of look at them and go, well, my bylaw is different than this one, but you know what? I like ours better. Is this an optional or is this a mandatory change? And sort of go through it like that, because I think that gives you a little bit of a checklist just by using that list. Next, of course, is amending and replacing is required, which will require, of course, votes by the board of directors, and then have them approved, which will need resolutions of your members to approve. So therefore, that's why I'm saying a 3-year period is a short period, because your annual meetings are going to have some of these provided at them. Filing the articles of amendment with the ministry, but not the bylaws. Bylaws don't have to be filed, but your amended articles will. And if you're a registered charity, you're going to have to file the documents with CRA's Charities Directorate. I think one other step that I think is important in this process, and I think is quite often overlooked, is that ONCA is not the only piece of legislation that that affects your business. And I think it's really, really important to have your legal and accounting people both involved in the conversation as you're going through this process. You know, I think it's easy to make changes that might affect CRA, that might affect different aspects of the business. And I think it's a good idea to have the whole team there, because the Income Tax Act can't be ignored. I think it's really too easy to make a change, not realizing it may affect your status under the Income Tax Act. So, so now that we've talked a little bit about the process and about what's going on ahead, I'd like to take a moment to discuss the director's role. And as I said, the reason I sort of chose the director's role and the members' roles is because I think it discloses several places where the bylaws might have to be reviewed and might have to be changed. And I've tried to break down the director's changes into two categories: one, administrative matters, and two, the liability of directors. So under the administrative matters, I've set out a series of boxes here. I'm not going to go through all the boxes in detail, but I'll talk a little bit about them. First of all, after ONCA comes into effect, all corporations will be deemed to have at least 3 directors. The minimum number of directors is 3. This is a default rule. Your articles of incorporation can provide for a minimum and maximum number of directors, so long as there is 3 provided somewhere. So you can have, this organization will have a minimum of 5, a maximum of 15, but you can't have any more. This organization will have a minimum of 2. There has to be at least 3 directors. So one of the things you're going to have to do is you're going to have to look at your articles of incorporation, make sure it sets out how many directors you have, and 2, make sure that the requirement is at least 3. If you're silent, if your articles don't mention it, or if your articles are less than 3, after the 3-year period, you will be deemed to have 3 directors. Directors may serve for a maximum term of 4 years before they need to be reappointed. Under the new legislation, there is no limit to how often directors can be elected, so they can be elected for 4-year periods for the rest of their lives if you want to do that. After the 3-year period, so after this 3-year holding period we're in, if you do nothing, your bylaws will automatically be deemed to say that your directors are elected for 1 year and 1 year only. So you might want to look at your number of directors when you look at your articles. In your bylaws, you might want to make sure you're happy with the number of directors you have and how long they can serve each term. The government doesn't say, it doesn't dictate that you have to have a term of a certain length. All it's saying is you can't have a term more than 4 years, and if you don't do anything, the term of your directors is going to be deemed to be 1 year, and 1 year only. Directors do not have to be members. If an organization wishes them to be members, that requirement must be set out in the organization's bylaws. Employees of a not-for-profit can be directors, but remember, if your organization is a PCB, Public Benefit Corporation, or whatever it stands for, only 1/3 of the directors can be members. And again, that has to be set out in your bylaws. One thing I thought was very interesting is a person is not legally a director unless he or she has agreed to the appointment in writing, even if they've been appointed by the board. So if you had a loosey-goosey system where you ask someone, do you want to be a director? And they've said, sure, I'll stand as a director. You've done your due diligence, you've done all of that stuff. The board's appointed the person. Under the new act, they're effectively not a director, unless what they've done is sent a letter in writing, signed, saying they confirm that they will act as a director. There's no form letter, there's no real guidance, but the letter must be signed, and it also must include the director's address. If it doesn't include the direct address, it's not a valid letter appointing a director, and it must be kept on file by the organization. From the liability point of view, and this is sort of near and dear to my heart, because as Joelle said, I'm a director of the United Way, there's a new statutory duty of care, which will now apply to all directors and officers of the corporation. Directors and officers must now act honestly and in good faith with a view to the best interests of the corporation and to exercise reasonable care, diligence, and skill. A couple of points about that. First of all, I find it really, really interesting that the legislation talks about the reasonable person. It doesn't talk about the reasonable director. It doesn't talk about the reasonable, in my case, lawyer or professional. It says the standards, what would the reasonable person have done in like circumstances? So it's not as high a duty as you might have imagined. The other thing that I think is important about this particular duty is that it's really not that big a change from where we are today when you think of it. Today, we have a fiduciary duty, right? I'm a fiduciary of the organization simply because of my role as a director, and as a fiduciary, I have a duty to keep the interests of the United Way above all else except the law. Can't break the law for them, but above all else, I have a duty to maintain their interests. So when you think of it, that's not a huge change from a direction to act honestly in good faith. However, this is the first time a director's duty to a nonprofit has been set out in legislation, so it is kind of a big change that way. The Act sets out a due diligence defense. If a director can demonstrate that they've fulfilled their duties with the care, diligence, and skill that a reasonable person, there's that reasonable person thing again, would exercise in similar circumstances, they won't be liable. So even if they made the wrong decision, as long as they can say, well, I acted reasonably, I did what a reasonable person would have done, they won't be liable. Also, a director may rely on in good faith on reports and from professionals. So as a director, I don't have a duty to look at the underlying details of financial statements. I can rely on reading the financial statements and relying on the professionals to come and talk to me about them when I make a decision. I do think there is one aspect of directors that I should mention, and that is, also, no, I won't mention it there, I'll just mention it quickly. And that is, I think that if I was in charge of governance of a corporation, a not-for-profit, I would be talking an awful lot about my board about having robust conversations for things. I think with this new duty of care and the duty of care that's owed, I think that it really behooves the directors to have a very vocal conversation. Because from my point of view as a director, I would hate to see something go wrong. And the only evidence of what I did as a reasonable person was the minutes of the meeting. And the minutes of the meeting show no discussion whatsoever. That there were no questions, there was no discussion, and that things passed. Because I think that's pretty good evidence that you did not fulfill your duty with reasonable care. But that might just be me. The other thing about directors I thought I'd mention before we move on and talk about members for a very brief minute is I thought I would set out the wording of Section 41 of the Act. So all these are basically cut and paste from Section 41, and it's respecting conflicts of interest and directors and officers. So the provisions in Section 41 provide some guidance as to what a conflict is and set out the duty to disclose is an ongoing duty. So in that a director or an officer becomes interested at a later date in contract they have a continuing duty to disclose. The requirements to disclose include not only contracts and transactions discussed at meetings of the board, but also contracts entered into the ordinary course of business by the organization. So they have to disclose conflicts there. And as an example, and it might not be a very good example, you guys might be able to think way better ones, but an example that I thought up of where a director might have a conflict in the future, but not necessarily what was originally discussed, is if a banker sits on your board. So we have a guy who works for, I don't know, BMO on the board. There's no conflict because the organization does its banking at, let's say, I don't care, Canada Trust, or TD, sorry, forgot to change their name, that's how old I am. 3 years later, that banker changes employment and moves from wherever I said he worked, BMO, and now he's working at TD where the organization does do their banking. Now he is in a bit of a conflict of interest, and now he has an ongoing duty to disclose. And I think that's going to be an interesting trigger to figure out how organizations look at these things and figure out when someone has to disclose and what systems they put in place. The last thing I wanted to talk about was members. So again, the rules respecting members I've set out here. If you want to have some different classes of members, so you don't want to just have one class of members, your articles of incorporation must set out the different classes of directors. So that's a change to your articles, and it sets out a whole bunch of things where the articles will eventually have to be filed. The articles must also now say what conditions attach to each class of members, including how a member qualifies for each class of membership. If a member can withdraw or transfer to another class, how is that done? Those all have to be in the articles. When membership in a class ends, how does a member stop being a member? If a corporation or organization can become a member, so is it just an individual, or can entities also become directors? And all of those things, if you have two classes of directors, must be set out in your articles. If your articles don't say what conditions apply to each membership type, then the conditions in ONCA's bylaw, draft bylaw, will apply. You will have one class of members, and each member will have one vote. So it's sort of a go back to the basics. At least one class of members must have voting rights in the bylaws. Members will be entitled to receive financial statements at least 21 days in advance of annual meetings. Members will also have the ability to apply to the court for compliance orders to force directors and officers to comply with ONCA, to comply with their articles, and to comply by bylaws. So there's a greater transparency and there's greater accountability because now members will have these rights. Through the usual standard corporate member tools such as derivative actions and a limited version of the oppression remedy. And I think we talked a bit about those already. If you want to talk more about those, that's fantastic. So the draft bylaws provide the system for disciplining members as well. And if you don't have provisions in your articles dealing with disciplining members, the new draft bylaws will apply in 3 years. And that provides that you have to give a member 15 days written notice in order to discipline them after the board has passed a resolution of discipline. They then then the member has the ability within 10 days, so within that 15-day period, they have 10 days in order to give written submission to the board about their position and how they feel about the whole thing. And then the board must make a decision based on not only what they've heard before, but also the the member's submission. So in a nutshell, those are some of the changes under ONCA. So I've thought out here just the 5 thoughts that I had when I looked at all my notes and thought of what I'd like to take away or what I hope you guys take away. ONCA provides new rules for incorporation and governance of not-for-profits. I think that goes without saying. The most important thing I think you take away from today is that 3-year period to amend your existing articles and bylaws. And in going through and looking at the language I've highlighted and some of the comments I made about directors and articles and members, you can see an awful lot of the things that you're now going to have to review because some of them are optional and you'll be stuck with the ONCA bylaws in 3 years, or some of them are mandatory. And as I said, failure to do any action today, which is your right, you can ignore it completely, will lead to a lot of confusion in 3 years. Those new audit requirements might be a great thing for your organization, and it's a great thing to keep in mind and look at. those new membership rights based on transparency, the right of to have a derivative action and the right of an oppression remedy, I think are tremendously important. There's more transparency and more rights for members. And the new director's statutory duty of care and the new due diligence defense, I think, is also one of the big highlights of the new legislation. So Joelle, with that, I will return it to you.
Thank you, Keith. It was a great presentation, a lot of information, but you also made it very consumable for us.